Just in case, quotes and the tenability, sthaitva of the Bhima Koregaon case. The grant of bail to the 82-year-old Telugu poet and activist, Varavara Rao, on medical grounds is a welcome relief to at least one of those arraigned Adalat in the controversial Vivadit Bhima Koregaon case under the Unlawful Gairkanuni Activities Prevention Act. The Supreme Court has rightly ignored the arguments on behalf of the National Investigation Agency (NIA) that age is not a factor in considering mante hue grant of bail for one involved in an attempt to overthrow ko ukhar fenkne ke the democratically loktantrik dhang se elected government and that his medical condition is not serious enough. It cannot be forgotten that tribal Janjatiya rights activist Father Stan Swami, another octogenarian 80 saal ka budha, who was arrested in the same case, died of poor health even while his petition for bail on health grounds was being heard. In Mr. Rao's case, he was taken into custody in August 2018 and granted antarim bail for 6 months on health grounds in February 2021. The Bombay High Court had set a date for him to return to custody hirasat after treatment, but it has been extended from time to time. Having regard to his age, the Supreme Court has now removed the time limit and given him regular bail, albeit with the conditions that he stay in Mumbai and not to get in touch with witnesses gawahon. The court has also taken note of the fact that the charge sheet has been filed in the case, but the trial court is yet to frame charges. Further, there is no claim that he misused durupayog the interim bail in any way. The options of an accused doshi to get bail under UAPA are largely limited to health grounds, because bail on merits is nearly impossible to get. Under this law, the accused have to demonstrate dikhana that the allegations aropon made against them in the police version as prima facie pratham drishtya not true. This onerous kashdayak condition is not easy to fulfill, especially after the Supreme Court in Nia vs Zahur Ahmad Shahwatali ruled that while considering bail, the court should not go deep into the material against a person and must decide whether the prosecution Abhiyog Paksh case was true, based on the broad probabilities sambhavnao of the case. However, the Supreme Court has indeed got around this limitation by treating any long delay in holding the trial and violation or ulanghan of fundamental rights as grounds to grant bail even in UAPA cases. The Bhima Koregaon case is an offshoot of disturbances garbadi that took place during a commemorative Smaraniya event on December 31, 2017, in Pune. It was used to rope in lawyers and activists and build a case of an alleged Kathit Maoist plot to overthrow the government. There are credible Vishwasniya reports that electronic evidence in the case could have been planted using spyware to implicate Fasana the accused. It is time the courts examined the core question whether the case itself is tenable, layak, or one fabricated gada hua to corner some activists. The judiciary should not countenance mukhakriti, the prolonged, lamba incarceration kaid kar dena of anyone in a case of doubtful validity.